Hello everyone, thank you so much for joining us today. We are doing our usual Wednesday webinar, and today we are so privileged to have with us an attorney that we've recently met that is very well respected and well known in the industry as far as dealing with small business owners and businesses in general that are working on government contracts. So I am going to let our distinguished guest introduce herself, but we'll be getting started with why you need an attorney as a government contractor. So, Ms. Peters, I will turn it over to you.
Yes, thank you, Myra.
No problem.
All right, this has got to be the most self-serving titled seminar ever, right? Why government contractors need lawyers, presented by, shocker, a lawyer. But there are some valid points to be made here. And once you get past the initial incredulity of, okay, what would a lawyer recommend, lawyer or no lawyer, let's get back down to who I am, what I do, and why some of what I say may be applicable to you. As Myra said, my name is Mary Dunn Peters, and I've been a lawyer for close to 3 decades now. I started out working in the government as a federal criminal prosecutor and at the Justice Department. And then I went into private practice, and so for the last 20 years, what I've really focused in on is representing entrepreneurs. And one of the areas of the entrepreneurs that I've been working with have been government contractors. Because you know what, Myra? That is one of the fastest paths to creating a successful business that exists today. And it's one of the best, the very best ways that someone who is not in a traditionally recognized group of people can find success because of some specific government contracting programs. So what I'm going to talk today is something called the perfect world and then the real world, right? Because everybody would hire a giant team of lawyers for everything. I know you all would, but that costs a lot of money, right? Not everybody can do that. So what I want to do today are talk about the kinds of situations where you might want to think about hiring a lawyer and why it would be important to do it, and some questions that would be important to ask specific to government contractors as we go into it. So that's kind of the agenda today, Myra.
Okay.
And what we'll do is take questions as we go, but let's start out with some areas where you may need some legal help as you enter the world of government contracting. Let's start out with corporate formation documents. And one of the first questions that I get is, what should I be? A PC, an LLC, a corporation, an S corporation? It just looks like a lot of letters from the alphabet. What does it mean? All right, so an LLC is what the acronym is for limited liability company. And today, most small businesses organize themselves as limited liability companies. Why? It's easy to do. You can go online and set it up really very quickly. And most people, many people will do it with an attorney. But government contractors need to be very, very careful about corporate formation documents, and we're going to go into that in a moment. I'll tell you why. It's to do with that very subtly devastating rule that the federal contracting lawyers will talk about, the rule of affiliation and control, extensible control. So we're going to talk about that because ordinary off-the-shelf documents that many lawyers and legal services companies provide may actually get you into trouble with those control issues for federal contracts. And that's not always apparent, so we're going to talk about what that is and why. Some other areas, and there are too many to mention in one webinar, Myra, but one of the things we look at is what are the 20% of the kinds of contracts that cause 80% of the problems, right? So today we're going to focus on corporate formation documents, buy-sell documents, confidentiality and non-disclosure documents, teaming agreements and joint ventures, employment agreements, vendor contracts, and estate and succession planning. But if you've circled anything, I would want you to zoom in on corporate formation documents and employment agreements, because that's what we're going to really focus in on today, but the target is going to be the teaming agreement.
Okay.
All right, that's the bullseye for today.
Okay.
All right, let's hit the next slide. So, remember when I started, we talked about what are the documents that really get you in trouble with the government. And I have a lovely picture of an elephant and a little girl on the slide for those of you who are able to see the slide. Well, the government contracting preference programs are all designed to help small businesses owned by disadvantaged groups. So size matters. So this is one of the only areas in business today where being the little guy, being a woman, being a person of color, a veteran, something that makes you different, something that may have caused others to maybe not give you that break you needed in business, yippee! The government has special programs to give you contracting preference, and that's why we're all here, and that's why you join great organizations like yours, Myra. You need to find out about those opportunities and really go after them. But here's the caveat. Size matters. Size matters. So, companies who are small companies may lose their status as a small business if they are affiliated with larger companies and people who have a high net worth, or they give control of the business to others. What does that mean? And I have quotes around the word affiliated. What does that mean? Well, you go to the government and you say, I'm a small business, look at my numbers, count the people, I'm it. Or just me and a few others. And the government says, you're right, and you are in an historically disadvantaged group. But because you've given others control over your company or your business, we're going to find that you're affiliated with them, either directly, legally, contractually, or ostensibly. And sometimes it's obvious. You know what, Myra, you can put it in a contract. Oh, yeah, you get to run my show. Or maybe you're doing it behind someone's back. Yeah, they're using my company, but really it's just a puppet for something else. And those are the kinds of people you read about in lawsuits by the government and sometimes civil complaints. Nobody wants to be there. But sometimes, Myra, it's really not all that obvious. And the government is going to look at something called negative control. Oh, holy cow, Mary Dawn, what is negative control?
Yeah, that's a great question. I see that all the time.
Yeah, what does negative control mean? Well, it means somebody's ability to block something. Where does that come up? So if we turn to the next slide, let's look at a very common scenario. And let's pick a veteran-owned company. Let's say you're a veteran-owned company. And in order to qualify under all the SBA and Veterans Administration rules, you're going to have to show that the veteran owns the majority and actually controls the company. Now, let's look at how that might come up in a business contract. If a non-veteran can block you from hiring, firing, taking an action like selling the company, then you're giving away control. And that ability to block is called negative control. So let's look at some of the common ways that that's going to pop up in ordinary business arrangements. For most people, no problem. It's going to be standard operating procedure. In a government contracting contract or business formation document, Myra, it's game over. Potentially game over. So let's move to the next slide. Let's talk about some very subtle ways that this can pop up. The first big way, and it's not on the slide that you're looking at, but the first big way that it comes up would be in your corporate organizational documents. Let's look at what I'm talking about here. You have a operating agreement if you're an LLC, or perhaps you have bylaws if you're a general corporation. And you have 3 or 4 partners, maybe a silent investor. Maybe one of the, you always bring a money guy to the table, most companies do, right?
Yeah.
You've got the people who do the work, and then you have somebody that goes,
the big bucks.
you know, I'm not going to be in there working on your business, but I like you. I like your business idea. I like your business model. I'm going to put some money into it.
Mm-hmm.
How many people do you know who are going to put money into it that don't want to have some ability to have a voice at the table, right?
Right.
So they put in your bylaws or your operating agreement something that looks like this. All parties have to agree before we will bring in a new partner. All parties have to agree before we get debt over X. All parties have to agree before we make up something.
Right.
It's usually going to revolve around all parties must agree. Usually it will revolve around a couple of areas. Bringing in a new partner, offering stock, getting a mortgage, creating debt, selling something. That's going to be where the money people start to get anxious. Or even if it's not a money person, what if you start the business together? Oh, we were all in it together. Shouldn't we be all for one and one for all? Well, not in the government contracting world, Myra. It needs to be all for one, not one for all, unless you're all veterans, or unless you're all in a minority that is traditionally oppressed, or unless you're all women. Otherwise, the negative control issue is a big old gotcha. Let me tell you another area, and this points to the slide that you're looking at. Very often overlooked, very controversial. I can tell you the SBA and the DoD, Defense Department folks don't always agree on this. Buy-sell agreements. Buy-sell agreements are those contracts that come into play when one of you leaves the business and or gets divorced and or dies or becomes disabled. If you don't have them and you have a business partner, I'm going to tell you right now, you need to do it. You need to get one of these buy-sell agreements, because there's a 50% chance that somebody's going to be divorced, just in the ordinary statistics of the population. Do you really want to be in business with your business partner spouse? I mean, maybe, but you should think about it. So under the buy-sell agreements, you have to look carefully Because there could be a situation that you create where a business partner buy-sell may create negative control by being overreaching. Now, is the government likely to get in your face on your corporate formation records or business associate agreements? Maybe. But where I see it coming up, Myra, is in the situation of your competitors. Woohoo, you just won your dream government contract, right? Mm-hmm. Happy days are here. I mean, you go on and on, you're celebrating, and shortly thereafter, your competitor files a big protest. Mm-hmm. And guess who's going to be scrutinizing your documents? So that's where I'm seeing that this really starts to come into play.
Yeah. Awesome.
So,
oopsie. Yeah, sorry, that's me and my magic mouse. There we go.
That's all right. Okay, so I've spent a fair amount of time on this issue of control, and it's something that all small businesses need to look at in every contract. But I think I've driven home probably with the baseball bat my point on that issue. So now I'm going to switch to one of my other favorite topics, confidentiality agreements. So confidentiality agreements go by different names. Confidentiality, non-disclosure, non-use. You need to put every kind of no you can into that agreement. And what a confidentiality agreement, an NDA, a non-use agreement, by whatever you want to call it, does. That's a document that says, I want to talk to you about something that's really important to me, a great business idea. Let's have coffee. Let's talk about it. If you do that without having a confidentiality agreement in place, guess what? You've just given it away now. And there's no getting it back.
I've seen it happen in real life.
And I'm going to tell you a pretty scary statistic. I represent a lot of businesses who are in the government contracting space, from giant ones to small ones to ones in between. And I will tell you that in at least 30% of the cases that I see, where a small business goes to a big business with a great idea, they don't have the NDA in place first. There's an allegation that they took my idea.
Wow.
And they ran with it. So there's no going back from that. And one thing I really want to drive home today, do not ever take your secret sauce to a competitor. And I mean nothing of value, until you have a confidentiality, non-disclosure, non-use agreement in place. Mm-hmm. And what I end up hearing from folks is this, oh, I'm worried that they won't want to keep talking to me.
Yeah.
Any sophisticated big business will use this under any stretch of the imagination before they go to anybody else with their business ideas. And I'm going to give you another piece of advice, because Myra tells me most of the folks listening to this broadcast are going to be smaller. Let's say the big company hands you, here's our NDA.
Right.
Just sign here. Well, don't. Until you read it hopefully have a lawyer read it. Why? There are two types of confidentiality agreements. One way and two way.
Oh, okay.
You want the mutual confidentiality, non-disclosure, non-use document. I have seen small businesses sign something. Oh, we did. We had a confidentiality. But guess what?
That protected them.
Yeah. The big company wrote it. It tends to be a little more one-sided. I'm going to ask you to think about looking at another aspect. And that is, how are they defining confidential? And in some of the big agreement cases, confidentiality cases that I've looked at, they will only define confidential as a written document that you've stamped confidential. Well, what happens, when have you ever conducted a business meeting where all you had was an exchange of documents?
Exchange of
Yeah,
papers.
let me pass you a piece of paper, Myra.
You read that?
No, I haven't done that since the second grade when we were passing notes, right? Didn't really get away with it then. It doesn't work today. So you've got to really look at those documents to make sure that they cover things like conversations. Okay? So there you have a tip from a lawyer. All right, now let's move past that. Let's look inside your business. You're hiring great folks. And as people like to tell me, hire folks who are smarter than you. Get the right people on the bus. Well, I did, because that wasn't hard to do. I hired a lot of really smart people in our law firm. But do you really have the right documents in place? Let me talk about where some agreements are going to come in handy. Employment agreements. But you might as well put underneath that independent contractor agreements. Let me tell you about a very common mistake that small businesses make today, and it's costing them a ton of money. Oh, I'm too small to have an employee, so I have only independent contractors. But, and I have a document that says that they're independent contractors.
Renzi knows where you're going with this.
Yeah. Oh, sorry, Renzi.
No, she's our HR guy.
Okay.
Yeah, so.
Let's talk about it. So the biggest, most fertile ground for lawsuits today, whether you've called somebody an employee and they're really an independent contractor. Note to self, in Georgia, there's a presumption that if you have a document signed by both parties that calls you an independent contractor, you may be viewed as an independent contractor, but it's a rebuttable presumption. Georgia's the only state in the union that has that statute. If you are in almost any other state, and in particular California, presumption is you're an employee. But the big risk area for most businesses, in addition to being sued by the people who work with and for you, is the government takes a different view. And the government decides, I don't care if you call this person an independent contractor. If it walks like a duck, and it looks like a duck, and it cracks like a duck, quacks like a duck, it's a duck. And what do I mean by that? Well, there are a laundry list of factors that they look at, the control issues. And if they can decide who hires, fires, when you start, when you stop, what you do, how you do it, quack, quack, quack.
That's an employee.
Yep. And if you didn't do withholdings, they're going to have a chat with you. And you know when that comes up most frequently, Myra?
When?
Okay, your agreement says you're an independent contractor terminable when I say you are. All right? You terminate. what do you think they do next?
Go to unemployment office.
Exactly. And off you go.
Wow.
All right, so have a lawyer look at it. They can help you with it if it's really important. So non-competes, non-solicitations, and our favorite, the confidentiality agreement. Why do you need to have these kinds of things with your employees? Your employees and your independent contractors have access to the secret sauce, do they not?
Mm-hmm. Yep, they're right in the middle of the sauce.
They have access to your customers. They have access to your manuals, your standard operating procedures, and they listen to the master. Oh, here's what I think would be a fabulous business strategy. The next thing you know, they're out on the street opening their own shop. Can you stop it? No. But can you prevent them from taking your trade secrets? Yes, you can. Yes, you can. Not always, but here's the deal. Non-competes are enforceable, but the laws in all the states are different. And courts will bend over backwards to find non-competes unenforceable. Why? They don't want people to be without a job and not able to work. That's against public policy, right? That makes sense. But non-competes can work if they are narrowly tailored to time, place, job. If you draft them narrowly, geographically, by time, and it varies from state to state, and that's why you need a lawyer. One size does not fit all. You have a better chance of making sure they're enforceable. And you can't be so broad that you say, I'm going to have a non-compete with the secretary. Is the government going to find that enforceable as a judge? No, no. But your sales manager, your IT person, those are areas that they're going to go, oh, well, let's look at that.
And if it includes that person's ability to hold their liability,
Right.
This is how they live. If it's so broad that it includes their ability to do that.
Exactly, exactly. So that's where the normal tendency, the business owner's tendency would be, I'm going to make this as broad as I can. But the lawyer will say, hold up, wait a minute. It's not worth the paper it's written on if it's too broad.
Right.
So let's not go there. Another area that you'll see very often is non-solicitation. What does that mean? People will put that in contracts with employees and with their business partners. And what that means is, after we part ways, you can't go out and solicit or ask my clients that we worked on together to come work with you. You can't ask my employees not to come work with you. That is also a restraining trade. It has to be tailored narrowly. Can't keep people from working indefinitely, but if it's done right, it's going to protect you. And that's why it may be well worth getting a lawyer involved. And again, on the whole confidentiality agreement, you can put in provisions, documents in place that tell your employees and put them on notice, these are my proprietary documents. Don't take them. You can't take my playbook and use it for someone else. And that protects you by having that confidentiality provision with your employees. All right, next slide. This is an area I like to tell people, a three-legged stool is more sturdy than a pogo stick or a ladder, right? A lot more stability. And what I like to tell my business clients is this. You better have the right back office team in place. And by back office team, I don't mean your employees. I mean the team of professionals that surround you.
Right.
You've got to have a great accountant. You've got to have a great insurance agent. And you should have a lawyer. But one of the things that your great team needs to be doing is occasionally talking to your other key players or team members. So your lawyer can be working to understand what your business really is all about and talking with you and your other partners, and I use that term not literally but figuratively, about insurance. Do you have the right insurance in place? Commercial general liability, employment practices, D&O, E&O, and cybersecurity. I want everybody to pay attention to that last word, folks. Cybersecurity. The threat is really growing. Lawsuits are picking up incredibly fast. And it's not covered by most insurance policies. You have to ask for a cybersecurity policy in particular, and if you don't cross the T's and dot the I's, even if you have one, it may not be worth the paper it's written on because you didn't follow what you needed to do when you had a security breach. That's where your lawyer comes in. It's a very scary world out there, and I can tell you this from personal experience and working with a lot of really excellent companies. They're targeting, the bad guys are targeting small and medium-sized businesses.
Wow.
Why?
Because they know they don't have the stuff.
And it's easy. It's easy. Why are they going to go after the Mac Daddy that has cybersecurity teams in place? Why wouldn't they go through the back door of a vendor?
Exactly.
And they do. And they do. So that is a very huge, huge risk. And before I leave that topic, and it's a topic for a whole other webinar, Myra.
Well, we will put it on the books.
Yes, we'll talk about this later, but if you are in the healthcare space, if you are a vendor to anyone in the healthcare space, you are their IT company, you are the copier repair person, you're the billing company, you're a consultant to a healthcare company.
Wow.
And that fits a lot of people. If you have or theoretically could have access to protected health information, you are now by definition a business associate. And I use the capital B and the capital A.
Wow.
What does that mean? It means that HIPAA high-tech rules apply to you.
Oh, wow.
Doctors, healthcare organizations, they've been dealing with this stuff since it came down the pike about a decade ago. In 2009, Myra, the federal government made clear that they were going to start going after the business associates, the people who are doing business with the government. In 2013, they said, hello, hello, we're really starting to go after you guys. In March of this year, Myra, they started saying, we told you we were going to do it, now here we are.
Wow.
We're levying big, big regulatory fines, and I mean $1 million fines.
Oh, man.
For not crossing the T's and dotting the I's. And what they are looking for is this one document called a Business Associate Agreement. It's something that the Department of Health and Human Services says you have to have in place. And if you don't have it, you're violating the rules. And if something bad happens and you didn't have that in place and you didn't have a privacy policy and you didn't take reasonable security steps, we're going to go after you.
Wow.
Not just the doctor. And boy, does it come in, it comes in not because anybody tried to do something bad,
but because human beings are human beings, and we lost a laptop,
Right.
or a cell phone, or, no, or some other smart device,
Mhm.
or someone hacked it.
Wow.
So, just heads up, that's a topic for another day,
Yeah.
but that's a serious topic and a document that you need to think about when you're talking to lawyers.
That's good to know. We've got a couple of members that would be defined as business associates, so that's good information.
Okay. Now I'm going to talk about something that all small companies looking to be giant companies are interested in, and that's the teaming agreement. Everybody's looking for that. And you have to ask yourself, a much larger company is talking to you about teaming together to get that fabulous government contract because they need a small woman-owned business, veteran-owned business, service-disabled veteran. They need to have something that gives them that competitive advantage when they're putting together the ideal team to bid on a government contract. So they come to you and they ask you to sign their form teaming agreement. Do you sign? All right, that's not a hard question. Dangling the big dollars in front of you, you might, but not without a careful review. And probably not without a review by a lawyer. And why? So, here are some terms of the teaming agreement. It's really important. Who are the parties? Why are they working together? This is very important. Are you the only sub that they're going to be working with? Is it exclusive? Or can they shop this baby? Are they using you as a stalking horse?
Wow.
Intent to team. Is there if-then language in the teaming agreement? If the contract is awarded to the prime shall award to the sub. And the teaming agreement, let's kind of put this in perspective, Myra, for those who haven't had that yet. When you have a government contract with a much larger company, you have a prime contract and a subcontract, right? So the teaming agreement is the agreement to agree. It's the before you even get to the subcontract.
Right.
But if you don't do this right, you're out. So that's why we're looking at these terms for the ultimate subcontract with the main partner.
Right.
Okay? So what else? Who gets to prepare that government bid? What part of the proposal? And are you even going to get a seat at the negotiation table? Are you even listed in the proposal? Here's a biggie. Who's going to pay the costs to prepare that proposal? Are you in for a little or a lot? Here's something folks don't think about until the last minute, or if at all. What are the confidentiality obligations? Any exchange of information, confidential information, is it pursuant to confidentiality and non-use? So that I'm giving you the secret sauce, but only in as much as you agree to use me.
Right, right.
And use it for this. What are the term and termination proceedings? And will these terms be engrafted into the subcontract? Do they survive this agreement? What if we never agree or get to a contract? And so the teaming agreement ends. You still want them to protect your confidential information. So you need to be able to say that term survives the termination of this teaming agreement. Freedom to market and exclusions. Can they tell you who you can market to and why? What are you bringing to the table in terms of your intellectual property? Does it stay your intellectual property? That's another whole topic for dealing with the government. But as between the two of you, the team, members. Indemnification and limitation of liability. This is the bet the company clause. The bet the company clause. Because if something goes wrong, you need to look at who pays, who's responsible. That, if it's in caps and it's all bold, oftentimes, unbelievably, people will eyes glaze over and think, boilerplate, not really important. That's when you need to really drill down. It's in caps and in bold because contract law has evolved to say you can't bury the important stuff, right? So that's why it's incredibly important to look at the all caps indemnification and limitation of liability. You need to limit your liability and indemnification duties to those risks that you control. Not all risks, just the risks that you control, and you need to make those provisions mutual. Okay, every contract has a choice of law. Delaware, Georgia. Most companies try not to make it California because it's really different in California. But I'm going to tell you, look carefully at Virginia law if you're a small sub and you want to try to avoid it, unless it's unavoidable. It's because of a case that we'll talk about in a minute called cyber law. You also want to look for things called arbitration clauses, which are common. Arbitration means that your case doesn't get decided in a court of law. It's decided by a private party. Well, that sounds like a great idea, and it's really fast, but it's also expensive. Both sides have to pay for the arbitrator. In a AAA arbitration proceeding, the arbitrator costs can be thousands and thousands and thousands of dollars. You will be $10,000 to $20,000 in it before you get into discovery.
Oh my gosh.
Potentially. It's not cheap. It may be less expensive in the long run than litigation, but one thing is for sure. Let's say you're trying to enforce your rights as a little company against the big company. You're going to have to spend thousands and thousands of dollars not only on the lawyer, but on the arbitration costs. And you may not have that in your budget to do. So that's a big old heads up. Generally, can you assign your teaming agreement? Are you guys independent contractors? And you want to look out for something called the merger clause. And that means it supersedes all prior discussions. So you want to carefully look and make sure that if you had a confidentiality NDA agreement before you started talking, that there's that provision in this document. Because if you don't have it and you have a merger clause, it may wipe it out. All right, let's go back to the cyber law consulting case. It started in Virginia. Prime and sub entered into a teaming agreement. Prime gets the contract, sub gets the door. Okay, sub wants to enforce the teaming agreement.
Right.
So what happens next is this. The sub sues. You breach the teaming agreement. The court said the terms of the teaming agreement were not definite enough. It was too vague.
Wow.
So no enforceable contract. Here's what's really scary about that. There were probably dozens and dozens and dozens of contracts just like that. It's just the first one that had been tested. So when people hand you their form contract and say, I've been using this for years, you better have somebody look at it and make sure it complies with cyber law, because the prime really doesn't have a lot of incentive to write an airtight teaming agreement, right? the burden's going to rest on the subcontractor to insist on terms that are ultimately going to be enforceable. On this picture, wait, I can help the prime win on the contract but be left on the bench? And the answer is yes. So can the government help me if my prime dumps me? No, not usually. Privity of contract exists between the government and the prime, unless the bid specifically includes the subcontractor. The government can't enforce your contract. Can the government give me a standard teaming form? Nope. It's up to you to find the flaws and read that fine print. So, if you have questions, and I've allocated 15 minutes, Mara, in case we have some questions.
Yes, we do.
I've left my name and my partner's name, and we have other partners that are very smart. If I can help you, I will. What I can't do in a webinar is give specific legal advice. What I can do is try to educate guys on some pitfalls. So let's go after some of the questions.
We do have a few. I'm going to start with the teaming one first, since we just got over that. So how can a subcontractor protect their interest? For example, post-submittal, how can a subcontractor protect their participation in the binding agreement?
So unless your teaming agreement and your subcontract agreement are clear, you're not going to be able to protect it.
Mm-hmm.
And that's kind of the point. Remember when I started out the seminar, very tongue-in-cheek, going, you know what, how self-serving that a lawyer's talking about, you really need a lawyer. But if this is your big opportunity, if this really is your chance to grab that grad swing, the bigger the risk and the bigger the reward, it's going to be a sliding scale. That's when you really need to talk to a lawyer.
Right.
So that's one area that I would work with that prime on the teaming agreement. Now there are some ways after you've been awarded a contract, and if the prime isn't treating you fairly, there are some flow down requirements. You may be able to get the government contracting officer to put some pressure on your behalf. But at the end of the day, if you don't have the language you need in the teaming agreement, if you don't have the language you need in the subcontract agreement, if you don't have a really tight confidentiality non-disclosure agreement to begin with, they may take your great idea and take it to somebody else.
We've got a few other questions, and this relates back to affiliation. So how does a mentor-protege program that a small business may enter into one of the official government mentor-protege programs, how does that impact control and that whole affiliation thing?
So mentor-protege programs are one of the areas where the government has softened some of the rules. And they have their own set of rules, but let me say this. You've got to have a protege relationship group. You've got to follow the rules. And if you do, it is a great opportunity.
Yeah.
It is a tremendous opportunity. But it's pretty illogical to think that they're not going to be exerting some influence.
Right.
That's what they're there for.
Right.
They're there to help you get that leg up. So the rules are different for mentor proteges, but there still are rules. They can't just engulf you, but they can work with you to help you achieve your goals of business well.
Okay. And then another question we've got is, and this goes to the agreements that we talked about, the employee agreements, et cetera. Are employee or independent contractor agreements necessary for partners? So, if you've got 3, 4 partners in a company, are those types of agreements necessary for the partners working and the people working for them?
I used to say no, but I've lived long enough that I will tell you my new business formation agreements tend to be a lot longer than the agreements that you will typically see for business formations for LLCs. And here, you start a small company, you're excited about it, everybody's working in the company, and everybody's getting a small salary. Company starts to grow. The original founders start moving in different directions. Somebody gets pushed out or walks out. Now what? So really, you have two different hats when you're working inside of a small business,
Right.
when you have partners. And I like to just put all the issues on the table for people to think about. You have your role as an owner entitled to a share of the profits, and you have your role as somebody who is working in the business. And how should you be compensated for that? Where I see people starting to come and go is, what do you mean, Mary Dawn? I have to pay this person. They walked out of here. They walked out. We were in it to be running it together, and the understanding was we'd all roll up our sleeves and work together. Well, unless there's a document that explains that concept, if somebody walks out at the very minimum, what you have is a potential lawsuit. Because those shares in the company, those membership interests.
Right.
So, well, I'm sure there are no problems. And so that's what I'm saying. Is it absolutely necessary? Yes. And it's a better idea than when every